Hello, everyone. Welcome to our live online audience. My name's Sarah, and I'm going to be the host for this session today. I just have one quick COVID statement to read, even though I know most of us are probably online. As you are all aware, mitigating the risk of spreading COVID-19 during the Congress requires the cooperation of all of us. In line with the COVID-19 prevention concept elaborated by our host country, Japan, and the Secretariat, I would like to kindly remind you of the following precautionary measures. Please fill in the contact tracing information sheet if in person. Maintain at least 2 meters of physical distance from each other. Wear your FFP2 mask at all times. Do not attend the meetings if you are unwell. And if you feel ill during a Congress session, please contact the medical personnel. These measures are in place for the safety of all of us, and I thank you for your support and attention. And I will now pass it to Mr. Zaza to moderate the rest of the session.
Thank you, Sarah, for the introductions. My name is Zaza Namoradze. I'm a director of Berlin office of the Open Society Justice Initiative. It's a great pleasure to welcome all of you, and good morning, good afternoon, good evening. It's a pleasure for me to moderate this session, which is co-organized by the United Nations Office for Drugs and Crime and my organization, the Open Society Justice Initiative, dedicated to the topic of ensuring procedural rights of suspects at police custody stage. Let me introduce the topic briefly, after which I will introduce the panelists, and then I will provide some information about the flow of today's session. One of central functions of the criminal justice system is to maintain public safety and security by detecting, preventing, and solving crime. Countless people are arrested and tens of millions prosecuted each year. In doing so, criminal justice systems need to guarantee human rights and fundamental principles of fair trial to ensure legitimacy and effectiveness and trust in the system. But the gulf between the law as it is written and the law as it is practiced and experienced is nowhere greater than in the realm of criminal procedure. This is particularly true at the entry point in the criminal justice systems, which often starts with police arrest. Decisions which will be made during the first hours and days of arrest will have significant impact on suspected persons and the fairness of the overall proceedings and consequently on its outcomes. But it is at this stage that core procedural rights, for example, such as the presumption of innocence or right to remain silent or right to defense, have little meaning or are not effectively accessible for suspects in custody. Laws are necessary but insufficient to respond to these problems. Many criminal justice systems in the world experience challenges with giving effect to core procedural rights for suspects and defendants in a way that makes them meaningful. Research shows that there is a need to understand constraints that operate on daily routines of police, investigators, and lawyers, and institutional and sometimes obscure bureaucratic impediments that shape organizational culture and daily bureaucratic and operational practices of police and other key criminal justice actors. There is a need to better understand drivers for certain forms of behavior in the delivery of rights, whether embedded in criminal justice systems or professional cultures of criminal justice actors. The impact of measures to address the COVID-19 pandemic has put a spotlight on the struggle of persons held in police custody and pretrial detention. This side event will explore what measures different jurisdictions in the world have been putting in place to improve realization of these rights in an effective and accountable manner, and the roles that defense lawyers, police investigators, prosecutors, and others need to play in this regard. We will start with Japan, followed by examples in Fiji and Nigeria, and then we will have brief comments from several jurisdictions in Europe and Latin America before we ending series of presentations from the UNODC. Then I'm hopeful that these short presentations will be followed by discussion to explore how the relevant criminal justice institutions and civil society can collaborate to promote relevant reforms aiming at improving procedural justice operational policies and practices. Let me briefly introduce speakers. Full bios are on the website, so I will not take more time with this. As I mentioned, the first speaker will be Koji Tabuchi, who is a professor of law at Kyushu University in Japan. His presentation will be followed by Shahin Ali, who is acting director of the Legal Aid Commission of Fiji, and then the speaker, Attorney General and Commissioner for Justice of Ogun State in Nigeria, Mr. Bolahan Adeniran, will speak about the experience from Nigeria. At that point, then I will have the kind of a roundtable format of quick, brief discussions on recent reforms in several jurisdictions in the European Union and Latin American countries, and ending with the present. And then in this regard, the presentations will be made by Georgiana George, who is the director of the Helsinki organization, Helsinki Human Rights Organization in Romania, and Nora Katona, who is a researcher at the Ludwig Boltzmann Institute of Human Rights in Austria. And our speakers from Latin America are Ana Aguilar from Mexico, who is the founder of the Institute of Criminal Procedural Rights, and Andre Castro, who is a public defender at the Rio Public Defender Office of the state of Rio de Janeiro. And then a speaker from UNODC, Wendy O'Brien, who in the works on issues of criminal justice and human rights reforms and equal access to justice at the United Nations Office on Drugs and Crime. There are participants. This session is entirely virtual. It is being recorded. That will be also available for later viewing. During our session, participants can ask questions using the question function on the right, and there is also the chat function where comments can be shared. At this point, then let me start with a round of presentations. And our first presenter is Professor Koji Tabuchi from Japan. I had the pleasure to work with Professor Tabuchi and with his research team on a study on effective criminal defense in Japan. This study was inspired by similar research which was implemented in Europe and Latin America several years ago. So Professor Tabuchi is going to share with us the key findings from this research, which particularly concern police custody stage in Japan. The floor is yours, and please, take up between 8 to 10 minutes maximum, given the long list of participants. I would appreciate if you could speak maximum of 10 minutes.
Thank you, Mr. Zaza. I'm very glad. I'm glad to have an opportunity to present here. So I want to share my PowerPoint. So can you see my slides? So
I do not see that. It's not appearing. I can see you, but not the PowerPoint.
Sorry. I try once again. Check button did. I tried to check button of start sharing, but no, it doesn't work.
It doesn't work.
Start share. I can't check start buttons now.
It doesn't work. All right. Yeah. I wonder if our host can help display
Could you change
that.
Yes, I have them ready to share if he needs me to.
Yeah. So Koji, so Sarah can share it and can go through that as you speak. If you can just tell her to flip the slide and yeah, so maybe we can do it that way. Okay, good. So we can see. So it's Sarah is displaying that. So Koji, if you could start presenting, then yes, please.
Yeah.
And I will keep the time, and please, if you do not mind, I may just give you the reminder if we are running out of time.
I'm sorry. Thank you. The project team of Kyushu University engaged in research on issues of effective criminal defense in Japan over 2 years with financial support from the Open Society Foundations and methodological advice from the Open Society Justice Initiative, and made the research report public in English and Japanese. You can get online versions from the shown URL. I'm going to explain Japan's current situation in Q&A format while picking up some static features of Japan's police custody from the research. According to the white paper on police 2020, the total number of detainees in police detention facilities was 2,938. 2,938,484 in 2019. Compared to this, the number of newborns in Japan was 865,239, and the number of deaths was 1,381,093 in 2019. That means for the people living in Japan, the probability to be caught by police was more than 2 times higher than the probability to be one of deaths person in 2019. However, this figure is not large enough for the majority to fear the arrest in daily life in Japan, I think. According to the white paper on attorneys 2020, the total number of duty lawyer calls from arrestees was 41,160 in 2019. Among accepted cases, the number of cases in which arrestees appointed the duty lawyer were 20,240. We can estimate from this fact at least over 20,000 suspects were arrested on grounds which needed continuous legal support by a lawyer in 2019. This number is large enough to justify discussing issues on police custody in Japan, I think. In Japan, a criminal investigation is ordinarily initiated by the police. They continue investigation until the prosecutor finalizes the case. Arrests are carried out in principle on a warrant issued by a judge. When the police has arrested the suspect, the officer must follow procedure and refer the arrestee to a prosecutor within 48 hours of the suspect being placed under physical restraint, unless the officer voluntarily releases the suspect. When a prosecutor receives a suspect from the police officer, the prosecutor must request detention with a judge or institute prosecution within 24 hours and within 72 hours of the suspect being arrested, unless releasing the suspect of their own volitions. If a detention warrant is issued, the detention period for the suspect is generally 10 days from the date when detention was requested. Additionally, extensions up to 10 days are possible in principle. If a prosecutor does not institute prosecution within the permitted detention period, the suspect must be released immediately. According to the statistics on prosecutions from the Ministry of Justice, 59.1% of detention cases continued more than 15 days to 20 days before prosecution, and 34.1% of detention cases continued more than 5 days to 10 days. While police arrestees are placed in police custody, the place of detention is designated by the criminal procedural law as a penal institution. However, the Act on Penal Detention Facilities allows a police detention facility to be used as an alternative to a penal institution. In fact, police detention facilities are principally substituted as places of detention to maintain the efficiency of the police investigation when police arrest a suspect. The National Police Agency of Japan explains as follows: to safeguard rights of detainees in police facilities, investigators are prohibited from controlling the treatment of those held in the detention facility. The treatment of detainees is in the hand of the General Affairs Division, which is not responsible for the investigation, and this separation of investigation and detention has been rigidly enforced. However, the detention officer, for example, does not have the authority or obligation to stop the investigation from continuing until midnight, and the functional separation of investigation and detention in police organizations is still inadequate. In Japan, relatively lengthy interrogations of suspects are conducted in physical restraint cases. No periodical statistics are available on the length of interrogations. The National Police Agency of Japan conducted a survey on interrogations by the police in physical restraint cases in 2011. Table 1 showed the average interrogation time according to the suspect's attitude. The interrogations of the 397 suspects in ordinary physical restraint cases at the 36 police stations selected from across Japan took place an average of 5.7 days and took an average of 15 hours 15 minutes. Furthermore, a study of 86 suspects of brutal and serious crimes for which Special Investigation Headquarters was set up showed that the interrogations took place over an average of 17.6 days and took an average of 65 hours 31 minutes. Notice of the right to appoint. When the police arrest their suspect, they must a. Notify the suspect of the right to appoint counsel, b. Inform them of the procedures for appointing counsel, and c. Inform them of the right to request court-appointed counsel if detention has been requested. Further, the circular notice of the National Police Agency of 2019 directs police to inform a suspect that if they ask to contact a lawyer during the investigation, the request will be immediately transmitted to a lawyer, both notifying and informing are performed orally. When a police officer received a request from an arrested suspect to appoint counsel and notified the relevant lawyer of this request, the fact is stated in the notification book for the appointment of counsel. Legal aid for the arrestee. Because the suspect does not have the right to court-appointed counsel until the detention procedure begins, bar associations have operated a duty lawyer system since 1990. The duty lawyer system was created with reference to the United Kingdom's duty solicitors. Upon request by an arrestee or their family, the lawyer on duty that day immediately heads to the police station or prison where the suspect is located and provides legal advice without charge on the first occasion only. Expenses for the duration of the services are paid for by the local bar association out of membership fees and payment from attorneys. To operate the duty lawyer system in a stable way, the final basis of this system should be strengthened by national funds. The Japanese government has cautiously tried to change the over-emphasis on interrogations and strengthen the centricity of the trial since the beginning of this century. The introduction of the Southern Judges trial in 2004 revision implemented in 2009 and the obligatory audio-video recording system of interrogations under physical restraint in the 2016 revision implemented in 2019 are examples of the attempts made. According to the Supreme Public Prosecutor's Office, interrogations in 103,380 cases were recorded by prosecutors countrywide from April 2019 to March 2020. Of these, 2.7% comprised two of the types of cases mandated by law to be recorded. 4.5% comprised four types of cases mandated by law or directed by the practice guidelines to be recorded. And 95.5% were other cases. Thus, still in most cases, the decisions of whether or what part an interrogation to record audiovisually is still at the discretion of the investigators. Criminal justice reform in Japan have not common to change the inquisitorial structure of investigation. In Japan, uh, if Japan were a country developing in the isolated world, it might be the best choice to reach for a justice system that reconciles the cultural inquisitorial investigations and human rights protection. But such an isolated country would never be sustainable in the real global world. We cannot stay at home all alone. We should promote justice from a worldwide perspective. Thank you.
Zaza, I believe you're muted. Yeah, Zaza, we still can't hear you. Can you make sure that your settings is set to use your computer mic? Because I think that was working okay before. Okay, so I believe we were having some technical difficulties with our moderator's microphone. I know the next speaker is Mr. Shaheen Ali. If I don't have any introduction for him, but if he would like to go ahead and give his presentation.
Certainly, I'm ready.
Can you hear me?
Yes, we can.
Yes,
Hello. I'm very sorry. Just something happened on my end, and the microphone did not seem to work. I hope it will cooperate better from now on. I wanted to thank Koji Tabuchi for the presentation, and ask Shaheen Ali to make his presentation, which is focusing on the innovative practice that Legal Aid Commission of Fiji introduced several years ago to ensure access to a lawyer and legal aid in police custody and during early hours of arrest. Shaheen, the floor is yours, and 10 minutes for your presentation. Thank you.
Hi. Can you?
No, I cannot hear you well. Your voice is breaking. Shaheen, it may help maybe if you put your you switch off your video and only speak on audio. Maybe it will help if the bandwidth is low, because the picture is coming kind of in a broken way.
Hear me now?
Yes, it's better.
Hi, can you hear me now? Okay, great. Okay. I don't know what
Okay,
happened. I
now
didn't
it's
hear
working.
anything.
Please go ahead.
Okay. All right. All right, great. I'll start. Bula and greetings from Fiji. Let me firstly say that this is an absolute privilege and honor to have been invited to an approach and experiences in the area of justice. Profession is founded on principles of equality and access to justice, the cornerstone of the Fijian justice system that is based on the rule of law. The Legal Aid Commission, although funded by the state, is independent of the state. In doing so, the legal aid scheme in Fiji meets the minimum standards set under the UN principles and guidelines. In respect of early access to legal for suspects in custody, because the rights were
Shaheen? Shaheen?
petitioner under the scheme for legal aid.
Yeah. So Shaheen, can you hear me?
Provisions in respect of the right to freedom from. Yes, yes, I can hear you.
Yeah, your voice is
Can you,
your voice is breaking. So maybe if you switch off your camera, maybe it will help.
okay, great.
So maybe we just use only audio in your presentation. It might help. Sorry for that.
Great. Not a problem. I'll do that. Hopefully, this is better now.
Yes,
So I'll continue.
we can hear better now. Yeah.
Awesome. Okay, so I'll continue. There are provisions in respect of the right to freedom from cruel and degrading treatment, which also covers torture. This provision covers all aspects of torture, be it physical, mental, or emotional. I'll now give you some background information on the first hour procedure, which is quite unique to Fiji, and perhaps Fiji is the only country in the South Pacific region to actually have implemented such a procedure. Fiji ratified the Convention Against Torture in March of 2016. Over the years in Fiji, we have seen cases of torture and ill treatment. In some cases, even the death of suspects whilst in police custody. These cases have been widely publicized by the national and international media. However, we've also seen the successful prosecution of police officers, with those responsible found guilty of murder of a suspect in their custody. Again, by investigating and prosecuting police officers responsible for ill treatment and or offences against suspects in custody is a good example of how seriously such measures are being taken by Fiji in order to comply with both domestic and international law. The ratification of the Convention Against Torture placed an obligation on Fiji to take preventive measures, either through legislative reforms, through administrative, judicial, or other means. The first hour procedure is one way in which the provisions of the Convention and the Fijian Constitution are being implemented. This quick and effective measure demonstrates Fiji's commitment to eradicating the culture of ill treatment, abuse, and torture through the coordinated efforts of the key justice stakeholders with the backing and support of the state. Perhaps one of the most significant achievements thus far has to be the coming together of the key justice sector institutions. In November of 2016, the pilot of the first hour procedure was officially launched in the capital city of Suva at 2 major police stations. The first hour procedure continues to date with the continued collaboration between the Fiji Police and the Legal Aid Commission, with support from the Chief Justice, the Director of Public Prosecutions, and the Fiji Human Rights and Anti-Discrimination Commission. Apart from fulfilling its constitutional mandate, the Legal Aid Commission Fiji has also incorporated provisions of the UN principles and guidelines in the provision of legal services to suspects and persons generally. A suspect is most vulnerable during the first few or early hours of arrest and or detention. There is a need to protect such persons at a time when they are most vulnerable. They must be treated fairly, with respect, dignity, and accorded their constitutional rights. The first hour procedure ensures that any person, regardless of their financial status, has access to a legal aid representative. This service is therefore available to every Fijian, including foreign nationals, 24/7. When a person is arrested or detained on suspicion of a crime, police are required to contact the Legal Aid Commission as soon as the suspect is brought to the police station and the suspect has been accorded his or her constitutional rights through the first hour procedure. The first hour procedure is provided face-to-face as opposed to over the phone. However, during the COVID-19 lockdowns that Fiji suffered last year, this unfortunately had to be done over the phone. However, that was only temporarily. It only lasted for about 5-6 months, and thereafter we are now providing this service face-to-face again. If the suspect does not want legal assistance, the police will call the Legal Aid Commission nonetheless, so that this can be independently verified and recorded by the Legal Aid Commission staff in the advisory forms that we have. This is done to also safeguard the police against any false accusations later by the suspect that he was denied access to a lawyer. After the first hour has been accorded, the police would then proceed to caution interview the suspect. At this stage, the suspect has the option of asking for a lawyer to sit in during caution interviews. I'll now briefly mention the video recording of interviews, which is quite new to Fiji as well, only a few years old, which has recently been implemented. Following on from the first hour procedure, it is prudent to also then mention the use of video record devices to record caution interview statements of suspects. Again, this is being piloted in the capital city of Suva. The Fiji police force has demonstrated great commitment in becoming more professional and improving investigative methods. Cases and allegations of brutality and coerced confessions have warranted the move towards actual and credible evidence gathering to support their case, as opposed to solely relying on confessions. The obtaining of credible evidence through a professionally conducted caution interview will ultimately improve standards of evidence gathering and provides the accused the opportunity to tell his side of the story without the fear of intimidation, threats, and/or physical violence. To this end, the Legal Aid Commission has conducted training for police officers, taking them through the constitutional provisions on the rights of suspects and accused persons, including international conventions. In addition, the UNDP office in Fiji and the Pacific has run complementary training for police on proper interviewing techniques, establishing, eliminating elements of the offense and potential defenses, as well as the practical conduct of the video recorded interviews, all contributing to the overall fair and efficient administration of justice. Whilst there may be genuine cases of ill treatment, there are also cases of false allegations against police officers, as we have seen through the first hour procedure. We anticipate the first hour procedure will protect the police against such false allegations and misconduct. It is also anticipated that over a period of time, all justice institutions will benefit from the process of the first hour and related video recorded caution interviews. We foresee a reduction in voir dire matters, including a reduction in false allegations of ill treatment by the police. These have a massive impact on trial proceedings, completely derailing timelines, requiring extra resources, effort, and time from the prosecution, in addition to sacrificing the court's available time and resources, establishing the lack of veracity for each case where alleged without bias. The first hour will hopefully, over a period of time, see a huge reduction in such allegations, but at the same time, reduce baseless or unwarranted pretrial detention and ward off self-incriminating and involuntary confessions due to undue pressure or coercion. Once the first hour procedure has been exhausted, the police would then proceed to caution interview the suspect. During this time, the suspect has the option of having a lawyer present, as I mentioned earlier. Video recording of caution interviews further strengthens the processing of a suspect in a transparent and accountable manner, in compliance with constitutional safeguards. There has been a directive issued by the Commissioner of Police that all pilot stations undertaking first hour procedures should conduct video recorded interviews for all caution interviews carried out. The video recorded interview ensures that there is no form of threat exerted on the suspect during the interview process, as the tone, voice, body language, etc. can play a part in intimidating a suspect and causing him or her to make involuntary confessions.
So 1 minute, please, if you could
Sure.
go to that.
Certainly. I'm on my concluding remarks now, Zaza, so I'll be done shortly. The Fijian Legal Aid Commission has led the way in promoting greater access to justice in Fiji. In respect of suspects and accused persons, again, the Legal Aid Commission has been in the forefront in fulfilling its legislative and constitutional mandate. It has complied with and is implementing the state's policies of eradicating torture and ill treatment through the first hour procedure. The Legal Aid Commission is committed to providing professional, quality, and efficient legal aid service to Fijians, and we view the first hour as an integral element of our service to the Fijian people. Thank you. That is my paper.
Thank you very much, Shaheen. You know, I congratulate the Legal Aid Commission of Fiji with this really impressive effort. It is extremely encouraging and you know, inspiring and helpful to already demonstrate and share with us the impacts that early access procedure and emergency legal aid scheme produces for the effective and trusted and accountable administration of criminal justice. Everything what you've said is what criminal justice systems need to achieve. And it's really incredible and really encouraging to see how effective realization of one very central right, that is a right of having a lawyer from the moment your liberty is restricted, how it helps realize all other rights and administration of the criminal justice system. So thank you so much. And I'm sure during the presentations and discussion, we will come back to some of these questions. Now I would like to go to another inspiring experience like Fiji. You know, there is another country in Nigeria, which is Nigeria, where a very similar effort was piloted and initiated by the government a few years ago, and it's now setting the standards for the entire country, and I'm sure beyond the country as well, in the region and further. So, Mr. Adeniran, so you have your 10 minutes, and if you could tell us about the effort that you've been pioneering to institute police station duty lawyer scheme in Nigeria.
Thank you, Zaza. I think it might be better if Sarah presents the PowerPoint. So I don't have to use much bandwidth from my end.
Certainly. So Sarah can then display your presentation, which I forwarded to her a few minutes ago. So hopefully she has it and she can display.
Yes. 1 second. Let me open it up before I start the screen share just to make sure it goes through correctly.
Mm-hmm. All right. I think it's being shared. So Bolahan, so I think you can go now.
Yes. So thank you. Good morning, good afternoon, good evening to everyone. Let me start by giving a bit of context on Ogun State. Ogun State is one of the 36 states in Nigeria. We completely surround Lagos, so there is no access to Lagos by land within Nigeria without passing through the state. Happens to be the most industrial state in Nigeria because we have the highest concentration of industries. And it is one of the unique states that is bordered internationally by Benin Republic. We also have a coast along the Atlantic Ocean, and then we have 4 states, including Lagos, that surround us. We have also obviously experienced police excesses in the use of police powers, so abuse of police powers. And we've seen that even though the Constitution is very clear as to the number of hours, so 24 hours and maximum 48 hours, police can hold someone in detention for filing a charge and presenting the person for criminal prosecution. We've seen that in many cases this time is exceeded. Unfortunately, we don't have a lot of data because it's very difficult to get that data, and some of the projects that I'm going to be talking about will show you what we are doing to overcome that challenge. We have also seen that the police have accumulated a lot of financial damages that have been awarded against them by individuals that have been held in detention for lengthy periods, and so on and so forth. And then just also so that you know, I came into office in January of last year. And since then, I've basically tried to understand the lay of the land. And I've seen, for example, that we do not have any formal, or we did not have any formal pro bono system. There's legal aid, because I like to distinguish legal aid from pro bono. We have the legal aid institutions, which are government funded. But in terms of a proper pro bono system, the state did not have that. So I'm going to go straight into the presentation. I'm going to be talking about, next slide please, the projects. There are three projects in one. First one, which is the one you're probably expecting, is the Police Duty Solicitor Scheme. The second one is the Custody Monitoring Dashboard, and then the Public Interest Law Partnership. In relation to the Police Duty Solicitor Scheme, next slide please, we are trying to ensure enforcement of fundamental rights of suspects, and there are many of those rights, including the right not to be tortured, the right to legal representation, and so on. And of course, we're trying to close the justice gap, because we've seen that many detainees belong to the lower income earning groups, and therefore, because they don't have ready access to lawyers or a voice, we see that they need protection. Next slide, please. And so what we've tried to do is to have 3 key institutions or individuals that have a role to play in this scheme. There's a police liaison officer who sits in the police station. There's a duty solicitor that is attached to that police station. And then there's the legal aid council, which is the legal aid institution. Apart from legal aid council, I will talk about the public interest law partnership, which is a new pro bono system that we've introduced. And then the Department for Citizens' Rights, which is another legal aid institution. And so all of them have to work in partnership. Next slide, please. And then the role of the police liaison officer is, he is the person that sits at the police station and ensures that this thing works. He's meant to ensure that the duty solicitor gets access to the suspects whenever he's present at the station. The system is flexible, so a duty solicitor may decide that he wants to be permanently stationed police command. Of course, that depends on availability, because they are all offering their time pro bono. And the police liaison officer also must ensure that suspects get the services of duty solicitors and reports within his own system to the Commissioner of Police, so that the Commissioner of Police can ensure that whatever challenges are being faced are addressed. Like this. In the role of duty solicitors, one, they have to maintain a 24-hour duty schedule. And we recommend on an 8-hour rotation basis, but we're flexible on that. Also, they have to report regularly at police stations, but like I said, they can also choose to sit, for fixed periods at the station. Next slide, please. They're to secure the rights of suspects and detainees. They are to provide reports, and this is one of the areas in which we're trying to collect data. The next project will also give you a bit more indication as to how we're trying to gather the data so that we understand exactly what's going on. Next slide, please. Duty solicitors are also to ensure that detainees are not kept beyond constitutional limits or that they are subjected to degrading or inhumane treatment. We also have the experience that we get a lot of confessional statements from the police. We now have new legislation that requires them to either video record the statement or take the statements in the presence of counsel. So it's either or. And this scheme, this duty solicitor scheme, is actually meant to assist the police in the latter. So even if they don't have the video recording equipment, they should be able to take the statements in the presence of counsel, which we think will strengthen the rights of the suspects. And then duty solicitors also to ensure that the suspects are not questioned in the absence of counsel. So that's to take care of the issue of confessional statements. Next slide, please. Then the legal aid counsel and other pro bono service providers, they have to make duty solicitors available. Currently, we have signed, you've seen the subsequent slide, over 100 duty solicitors that have signed up. And they also, beyond the duty solicitors, because the duty solicitor monitors detainees, but he's not the legal representative per se. So he's supposed to then connect the detainee with a legal representative. Next slide, please. So where we are, because this is a new project, like I said, we have over 100 duty solicitors that have signed up. We have linked them to 30 police formations. The 30 police officers have also been appointed as police liaison officers. And then we've done one training workshop for duty solicitors, and we're in the process of, next slide please, of doing a second training workshop to cover those that were not covered in the first. The scheme will be formally launched in April, and what we're trying to do is then, once it's officially commenced, we do all the publicity and we publish the details, as contact details of the solicitors in the different areas where they are to act. I'll quickly go through these two other projects. These will not take time. Next slide, please. The custody monitoring dashboard is one of our attempts to try and collect data. And so this is something that will be in place in each police formation. It will tell us the number of detainees in custody, the length of time the person has been in custody, and we're able to also obtain averages, the type of offense, because unfortunately in our system, and I say unfortunately, we do not have fixed rules as to how long someone can stay in detention if they're being accused of a capital offense. We have rules that say it must be reasonable, but there's no fixed period. And that's sometimes difficult to enforce. Then the type of release, so as to make us understand how people are getting out of the system. So whether it's by bail, if we see that the bail is unnecessarily cumbersome, then we can focus on trying to reform how bail is administered. And also whether it's by remand, if they're taken to remand, if that is working well, then it shows that the system is functional. And so next slide, please. It shows you what the custody monitoring dashboard looks like and how it can be viewed. There are many variations of this, but it just shows you one of the iterations. And the idea is to allow the head of a police formation to have the data to take the decision, because what we found and what they sometimes tell us is that because they are so busy, it's difficult to keep track. And, it's difficult for them to know when a suspect came in because that's not really their role. But now we're making it their role. And hopefully with this, we can collect some additional data. So, next slide, please.
One minute, please.
Okay. The dashboard is currently operational in one police formation, and all the officers have been trained in relation to it, and we hope that it can be replicated elsewhere. Then the final project, and I'll just talk through it, there's no need to present the slide, is a public interest law partnership. And this is essentially a clearinghouse with Nigerian Bar Association as an association of lawyers, providing pro bono lawyers in their areas of expertise to support indigent clients. And this is something that is going to be replicated across the state, and pro bono lawyers will be available to indigent people, including detainees, everywhere. At least 40 lawyers have signed up, and we're trying to launch it in April, but we're trying to get a few more lawyers on board so that we will have enough clients or enough lawyers to take care of the needs, because we did a pro bono needs assessment and we saw that the need indeed is great, and the 40 lawyers that we have currently signed up might not be able to cater for that, but we have to start from somewhere. So let me stop at this point, and I can provide more information during the question and answer session. Thank you.
No, thank you so much, Bolahan. Super impressive reform initiative that we just heard about. Really congratulate you and your colleagues with this effort. When I started to work 2 decades ago, I would say, on the issues of providing early access to a lawyer and legal aid to suspects, it took me some time to realize that it was not about lawyers. Actually, it was about police and prosecutors and investigators. And much what you described really demonstrated how critical it is to work with police and actually work out the mechanisms and systems that can facilitate realization of procedural defense rights, and the critical importance of custody, electronic custody record systems. That's really impressive. So again, indeed, your example from Fiji are showing the way how to address similar problems anywhere in the world. So now let me take you to another continent where about 10 years ago, and I'm talking about the European Union, an effort was pursued to establish common minimum procedural safeguards for suspects and defendants in criminal proceedings for the EU member states. This is essentially creating the directives which then have to be transposed and implemented by all member states, and there is a strong monitoring mechanism to ensure that those are implemented. Those directives concern the right of access to a lawyer, right to access to legal aid, right to know your rights, and a number of other critical procedural safeguards. Many countries in Europe, until 10 years ago, did not allow a lawyer to be at the police investigation during custody stage, like in Japan now, for example. But now it has changed, it theoretically as well as practically. But we are going to hear from our colleagues from Austria and Romania how in practice the new directives are being implemented and what are the challenges that limit or constrain effective realization of the directives in Austria and in Romania, using those examples. So maybe, Nora, let's start with Austria, and where until that reform, actually there was no right to a lawyer in police custody. Then suspects were not actually advised and assisted during interrogations and or represented in any ways until essentially the case went to court, and it had, then the new legislation changed that significantly. So what has been the implementation process? If you can give us a short, the remarks on that, and how you see the process going forward, where you see the biggest problems with realizing the directive standards. Nora?
Thank you very much, and also thank you very much for the kind invitation to speak about Austria. So yes, as you have mentioned, the directives were transposed into law in Austria and also in the other member states in the European Union, but there are still practical challenges and practical gaps. So before I go into the substantive part, maybe just briefly let me also mention the question about numbers, data, and statistics. So I think this is also a big challenge in for us researchers in Austria, because the latest data and statistics that I have are from 2011 and 2012, which were conducted and gathered in the framework of a research project. So please just let me underline again this question of data and its availability to us. When it comes to pretrial access to legal advice in the early stages, there are still some gaps and challenges. So if we go back to the numbers in 2011 and 12, before the police interrogation, less than 10% of the suspects were represented by a lawyer. And this number was even lower when we really look at the number of cases when a lawyer was assisting during the interrogation one of the suspects. This, based on the numbers that we have from research, approximately 2% of all of the cases, which is a very, very low number. During our research, because we were also in the Inside Police Custody project in Europe together with 9 other member states, we have found out that these numbers were getting a little bit better. Unfortunately, we don't have any data on that, but based on interviews and also consultations, we have heard that the situation is becoming better, but is still very far from ideal. What are the reasons that there are so little persons represented at the police station? In Austria, there is no mandatory defense at the early stages of the proceedings, especially at the police custody and at the police interrogations and investigations. So meaning that if they are not the person is not in a very specifically vulnerable situation, there is no mandatory defense. This means that very often the right to access to a lawyer is waived. When we were asking in the framework of our project what the reasons are, there were manifold. Just to mention a few, and the one was, for example, that the weight of the police recordings was underestimated. Underestimated, and in addition, also some of the suspects whom we interviewed was telling us that they had the feeling if they ask for a lawyer and they're using the procedural safeguards, they are proving somehow themselves guilty, which of course is also a big question and problem concerning also the presumption of innocence. And of course, there is the question of allocation of costs. And also there, this was one of the main reasons why people and suspects are waiving their rights. For a very long period of time in Austria, there was no legal certainty if legal aid is available at the police station. So until 2017, there were different cases, and also the case law differed very much and varied in this regard. So it was not ensured legally that there is legal aid available to people during police interrogation and the investigative phase. This changed a little bit in 2017 when legal...
If you take 1 more minute,
yeah.
No.
When a legal standby concealing service was introduced to practice, this is basically an arrest hotline, of course, and we have found out now also during the COVID-19 situation that this cannot replace in-person concealings, but at least there is the availability to have a first call to a lawyer. This is available free of charge and 24/7. Yeah. So meaning that there is at least the possibility for suspects to have an early call and get some legal advice. And of course, these are just mentioning legal aid and access to a lawyer, but there are also overarching challenges that we have heard before, like audiovisual recordings, but also the exclusion of evidence if there is a violation at the police station. And of course, for us researchers, the main challenge and the main question remains how this gathered information based on research and good practice examples we can really translate into practice. How we can really somehow bring along change. So that's why I was also very grateful for the presentations and for the very interesting insights into the former project to really see how change in practice can happen.
Yes, No, thank you, Nora. And just for our audience, I wanted to mention that several years ago we worked together with a number of colleagues in Europe to implement a research which used the direct observational methods in police stations to understand how processes and procedures worked during arrest and the first hours of detention with respect to procedural rights, and those were really the ways in which it was possible to establish where the real problems of implementation were, and what were the constraints that Nora just addressed. And of course, there is a lot that remains to be improved, but some of the improvements could already be observed as a result of EU legislation. Another jurisdiction that we have at the panel is Romania. Georgiana, who leads one of the human rights organizations in Romania, has been very active on these issues as well and participated in the research that I mentioned. So, Georgiana, if you can also briefly share your perspective, so where the problems remain with implementation, and what are the reasons that those issues are not really improving despite the EU legislation, which is quite detailed, quite clear, I think, in this regard. Please.
Thank you so much, Zaza, for the invitation. I'm really honored to be here. I'm very conscious of the time, so I'm just going to be very, very brief. I'm going to share my presentation if it is possible. I'm not sure. I cannot see it.
So you don't see the sharing icon on the bottom of your screen?
Wait, great. I will do it right now.
Okay.
I had several slides, but I'm just gonna go straight to the practical implementation of a few of the directives you mentioned. I'm gonna focus on access to a lawyer, legal aid, and maybe a bit right to information. We, as a human rights organization, have been working a lot on criminal justice issues and fair trial rights, and starting with 2014, so basically 6 years ago, we started working on transposition and implementation of EU directives, and it sort of coincides with a very tragic in Romania, and that was the death of one perfectly healthy young boy who was led to the police station and died there, beaten by police officers. Working more closely with the Romanian police or in better regulating any type of measure which is privation of liberty measure, be it administrative or criminal. And in 2017, we were lucky enough to be part of such an innovative project, the police custody project, and we were lucky enough to be able to be one of the countries who were granted access in police stations, and we were able to observe what is happening during police arrest, which is a maximum 24 hours measure, and we were able to participate during police hearings and observe the interaction between police officers and lawyers, and we were able to draw some very practical conclusions and recommendation on the issue of implementing these directives. So on the issue of the right to a lawyer and access to a lawyer, Romania is one of the countries whose law is perfect on paper. We have transposed almost everything. We have a mandatory defense system for the deprivation of liberty measures. That means that any measure which deprives one of liberty has a mandatory lawyer attached to it, which present during the hearing. You have the right to consult the lawyer prior to questioning, but it's not really an effective consultation. From our observations, the consultation at the police station lasted on average 5 minutes, maximum 10 minutes. There is lack of confidentiality of these consultations. we could observe they were taking place on corridors or interrogations rooms with the police officers present. And during the interrogations, it was not really clear what the role of the lawyer was. He was not able to participate effectively due to various reasons, but one of those reasons is because there is a lack of guidelines detailing the role of the lawyers and how he or she should interact with police officers. There is no criminal procedure provision in this sense. So that was really a huge problem, because even though the lawyer is present effectively. What we did after this project with the help of Zaza and Open Society Justice Initiative is to create a working group of lawyers, police officers and civil society, and basically put on paper what these interactions between lawyers and police officers should be from the moment the lawyer enters, the moment he gets out. And you can see, but it's a 6 pages very clear step-by-step guide. This interaction would be what the time the lawyer should be present in the police station, how he should access the case file, and how he should behave during the interrogation, how he should interact with police officers. We had the support of the police, and the plan was before pandemic to actually go and see it implemented in the police stations. We were not able to see if this happens, but there is cooperation on behalf of the police that these guidelines will be present at the police stations for an effective implementation of the right to defense. Because another problem is related to the legal aid system. Another problem is related to the legal aid system, and what I want to say is that we need to do more about ensuring qualified and competent lawyers, and we need to work with Bar Association in order to better train young legal aid lawyers who go and provide legal aid and defend suspects and defendants during this stage. I'm just gonna stop here because I realize the constraints.
Yeah.
Thank you, Zaza.
Thank you so much, Georgiana, and apologies for again limitations of time that makes it difficult to allow sufficient time to all comments and presentations. So thank you again, and then it was great you emphasized the importance of detailed guidelines for the interaction between police and lawyers, and they also need to really know what is implied in those functions they are performing in the system, and then really, like we heard from previous presentations as well, it really starts with legal aid system. There is no adequate funding, adequate resourcing in the legal aid system. It's very, it cannot work. There cannot be a proper realization of, the defense rights. So let me now take all of you to two Latin American countries. 5-6 years ago, with a group of researchers and human rights organizations, we published a similar research on effective criminal defense in Latin America. And I would like to ask Anna first. It was 2014-15 when the report was launched. In Mexico, many similar issues were established that we just heard from other colleagues. Have things improved since then? It's 5-6 years after that. How are you observing, in terms of the realization of defense rights and improvement of those rights in Mexico? Which direction are things moving? And then if you could limit your comments into 4 minutes, I would appreciate that we can ensure that everyone will have the time to speak.
Sure, I'll be just very short because as you mentioned, I will not share the presentation because I think it would take me more time. But the criminal defense system in Mexico is founded on the unwaivable right to a defense from a public or private lawyer. Just to mention that our legal system, although primarily represented by the public defense institutions, also includes legal clinics in universities, pro bono areas in private laws, law firms, and civil society organizations that provide legal services at no cost. Effective criminal defense in Mexico presents a series of challenges due mostly to systemic problems. And just as you mentioned, Sasa, our findings in updating our findings from the study, unfortunately, we cannot see many steps forwards, maybe some jurisprudence, like more progressive jurisprudence. But let me just pinpoint some particular topics that affect effective criminal defense in Mexico. So we have mandatory pretrial detention in our constitution. We have a catalog of of crimes and criminal categories that oblige judges to rule pretrial detention in those cases. And unfortunately, when we did the study, this catalog existed, but it was around 10 crimes in this catalog. This catalog doubled 2 years ago, so we have now around 19. This distorts, of course, the whole procedural system because it's not, beside the obvious breach to the right to presume innocent and the right to remain free during the process, in practice, really, this amounts to a very high number of retrial detention in the system. So also what we've seen is that there are certain rules particularly in our National Criminal Procedural Code that affects effective criminal defense because, for instance, judges are obliged to request the appointment of a public defender to assist a private defender prior recommendation to the accused to change her defender if the judge considers that the counselor does not have the technical capacity to defend him. So this provision, of course, it's very problematic as you can imagine. But it has also a negative effect in practice since it has led to differences of opinion during the hearings between the private lawyer and the public defender appointed to assist the person. This increased workload has also presented important challenges. I did a survey, very small survey very recently, and in some states it has also generated conflicts of interest as the same defender is forced to assist co-defendants. So this is something like an update, and unfortunately it hasn't worked. In terms of torture, we found in the study in Latin America, in Mexico particularly, that the bad practices persisted. The period between the actual detention to bringing the person to the custody prosecutor never gets really to the time frame allowed by the Constitution. It keeps being the same, and it's a high risk period of time for torture. This was confirmed after our study with the report from the United States Special Rapporteur on Torture, who said that the torture was a widespread practice in Mexico, and particularly that being a woman increased the risk of abuse and sexual violence during arrests. Also, that the profile of torture victims corresponded to people in a vulnerable socioeconomic situation. So, right information, not so many changes. It's not, the information on arrest and detention is not really transmitted sufficiently to exercise the rights. We have a particular problem with a lack of mandatory professional rules. That hasn't changed at all. We have no bar, nor certification, nothing that allows us to show that we are actually qualified to practice law or are specialized in criminal proceedings. So that's the update in Mexico.
Thank you, Anna, so much, and I for telling us about some of the issues that are that continue to cause the challenges to the defense rights in Mexico. Now we will go to Rio, with Andre, who works for one of the largest public defender office in the country, which is engaged with realization of those rights in Brazil, giving meaning and effect to the right to counsel in custody, realization or custody hearings, and other challenges that continue in Brazil. And Andre, it would be great also if you could just focus where you see the critical problems that need really to be resolved in order to improve administration of the criminal justice and the realization of fair trial for suspects and defendants. If you could take 3 to 4 minutes, please. Thank you.
It's a great task to do that in 3 minutes, but I will focus on the custody hearing. And to say in 2015, the National Council of Justice of Brazil adopted the custody hearing. I mean, people arrested should be presented before court within maximum period of 24 hours. And this court must have a public defender or a lawyer to assist the person. Despite some resistance from the public opinion and from sectors of the judiciary and the prosecutors, this decision was confirmed by the Supreme Court and recently was enacted as a federal law. Throughout this time, the concrete experience has shown that custody hearings are an effective tool to prevent torture and also contribute to reduce the number of people sent to pretrial detention. Many of the judges of these courts are being helped by a team of consultants to help them and detect signs of torture, follow up on suspected cases of abuse, and implement good practice. It's worth saying that this team of consultants were trained by the Association for the Prevention of Torture together with the UNODC office in Brazil. Also, the custody hearing have been quite important to identify the profile of the people arrested and the violence they suffer at this moment. According to a study by the Public Defender Office of Rio de Janeiro, 40% of detainees reported having suffered torture or ill treatment in the time of the arrest. And considering the rate of aggression by color, race, about 80% of them were perpetrated against Black people. The report also found that almost 80% of the people arrested in flagrante delicto and also 80% of the aggressions detected in custody hearings were reported by Black people. The remarkable advance represented by the custody hearing, however, suffered a setback during the pandemic. In last November, the National Council of Justice authorized custody hearings by video conference during this pandemic. The Public Defender Office is against this decision and conducted a survey that confirms the importance of a face-to-face custody hearing to prevent possible ill treatment, torture, and other violations. In the period of when the hearings were suspended due to the pandemic, there was an under-reporting of records of violence against detainees. Just to have the numbers, during this period, only 0.8% of the arrest records indicated the occurrence of torture, in contrast with 40% of the cases reported between September 2017 and the same month of 2019, when custody hearings were held in presence. Detection of torture is greatly aided by the physical presentation of the arrested person before the independent defense lawyer and the judicial authority, as well as by in-person access to an independent medical examination. All of this is rendered impossible with the remote custody hearings. Because of that, Brazilian NGOs and public defenders, and also lawyers, issued an appeal to the Inter-American Commission against the use of video conference in custody hearings.
Thank you.
Thank you,
Thank you
Zaza.
so much, Andrea. And you touched upon a very critical point, which we also wanted to really capture well at this session. That is how the COVID-19 is putting pressure on realization of the rights, and what you describe is really disturbing. How significant increase in or the problem is with lack of reporting, ill treatment and torture compared to the period when custody hearings and access to lawyer was effectively better realized than in how the constraints are leading to worsening of those problems. Now I'm going to Wendy, and I would like to ask Wendy, and seeing that we have very little time left, and I hope that the host can extend our session at least by 3 minutes to give you the sufficient time to present. It would be great, Wendy, to see, hearing all these problems, and none of that is new to you, having practiced and in Australia and worked in this field and now working for the UNODC, and then seeing also the Kyoto Crime Congress Declaration that emphasizes importance of timely and effective access to legal aid as a priority for the next 5-year period, and the need to develop tools and capacities and materials that UN and other agencies can provide. So where do you see the priorities, and how can things be addressed incrementally, I guess, but what it is that you think that UNODC will be doing to improve this area?
Many thanks, Zaza, for that introduction, and also I would like to extend my thanks to you and the Open Society Justice Initiative for hosting this session on this important topic. And perhaps I can make some remarks in response to your question by referring to some of the work that we have undertaken at UNODC in this last year. Because we recognise that the international legal basis for the provision of legal aid is clear, and the international commitment to the provision of legal aid is clear. We have the basic principles on the role of lawyers and the United Nations principles and guidelines on access to legal aid in criminal justice systems. But despite the strength of this commitment, we recognise in our work the global scale of the challenge in ensuring equal access to justice via effective and fair criminal justice systems. And on a daily basis around the world, individuals very often face challenges in accessing justice, or they endure harm as a result of their contact with law enforcement and justice systems. And among the many obstacles to justice that we observe are a lack of services, poverty, inequality and corruption, the criminalisation of victims, discriminatory or deficient law and procedure, undue delays, or alternatively, overly expedient processes, an over-reliance on punitive approaches and harmful stereotypes or social norms that bear discriminatory effects. So, in response to this challenge, and at the heart of our work as UNODC, is the provision of technical support to member states to ensure the implementation of international human rights law and the United Nations standards and norms in crime prevention and criminal justice, more than 50 instruments relevant to the field of justice and victim protection. And our work at UNODC is to build the capacity of criminal justice systems to ensure the effective application of these internationally agreed standards and norms. And so relevant to our topic for today and key to UNODC's work is the recognition that justice actors and institutions are the gateway to justice. Police, for example, have the scope to facilitate access to justice, to uphold procedural rights consistent with the international legal framework. Yet in situations where discriminatory law or practice prevail and where impunity persists, we know that there are risks that police can obstruct access to justice, resulting in a direct or indirect violation of rights. So for this reason, UNODC also promotes professional standards of conduct among criminal justice practitioners, consistent, for example, with the Code of Conduct for law enforcement officials and the basic principles on the use of force and firearms by law enforcement officials. And to support the implementation of these standards, we also work to improve systems for monitoring and oversight. So perhaps I can draw on a few examples from our work in 2020 to illustrate the scope of our work relevant to this topic. Under a joint project in Sierra Leone, Liberia and Senegal, UNODC and UN Women strengthened the capacity of legal aid providers on the delivery of tailored assistance to women and girls, offenders, victims, and also victims suspected or charged with an offence related to their self-protection. This project also delivered grants to civil society organisations to enable the continuity of legal aid service for women suspects, prisoners and victims. Noting an increased demand for such services during the pandemic, this project included research to better understand how COVID-19 has affected women's access to justice. Under a separate project and in an effort to reduce the number of under-trial prisoners in Pakistan, UNODC hired a team of 21 lawyers to enhance access to justice in the High Court, Session and District Courts in the Sindh region. This project facilitated legal support for prisoners in need, including by lodging release requests with the court. Lawyers pursued cases until release or conviction, and the project exceeded targets, with the majority of cases resulting in release, more than 500 in all. Under this project, and in recognition of the key role that police, prosecution and prison staff play in upholding the rights of pre-trial detainees, the project also focused on strengthening coordination and cooperation. In our work, we've also found that the pandemic has put a spotlight on the absence of data in many countries for evidence-based reform and action on accessing legal aid, and to assist in remedying this gap, UNODC is in the final stages of developing a comprehensive legal aid assessment tool. This will help build evidence bases on legal aid, including by capturing data on the role of criminal justice actors, such as police, in ensuring access to legal aid at the earliest stage. And this emphasis on an evidence-based approach underpins all our justice sector work. At the global level, for example, UNODC contributed to the development of a new evidence-based methodology on non-coercive investigative interviewing to promote the skills and understanding among law enforcement officials that is needed to acquire reliable information. The core principles of investigative interviewing are informed by a robust evidence base that indicates more effective law enforcement investigations that are also more compliant with international human rights law. And indeed, in his earlier remarks in this session, Mr. Ali from Fiji shared an example of interviewing techniques of this kind. Investigative interviewing is particularly important as a mechanism for mitigating the risk of coercion at the interview stage, which is, of course, a clear breach of suspects' procedural rights. This approach is also consistent with the international human rights framework and the recognition of inherent human dignity. With the investigative interviewing approach, law enforcement officers are trained to recognise the importance of the suspect's voice, including by providing the space for suspects to explain the facts in their own words without the risks imposed by leading or closed questions or other coercive means. This work on investigative interviewing contributes to UNODC's broader work in strengthening the pre-service and professional development training for law enforcement officers to promote the core competencies for human rights-based policing. And in 2020, UNODC adapted to the challenges of the pandemic to deliver online training for law enforcement officials. An online training developed for Kenya reached 50,000 police officers, for example. And under a separate project, UNODC Justice Section in partnership with AirCop and CrimJust delivered online training to more than 100 police officers in the Caribbean with the aim of building capacity and practical skills for policing with integrity and accountability. And this training also promoted a practical understanding of the importance of non-discrimination in policing. And perhaps before closing, I'll make a quick point about non-discrimination, because 2020 was a year of renewed attention internationally to the importance of eliminating all forms of discrimination in policing practice. And this is a particular focus of our work, with recent UNODC projects working to support member states to confront and eliminate the entrenched problems of bias and differential treatment in law enforcement contexts. And a key component of this work is building capacity to achieve diversity within the criminal justice workforce, whereby minorities and vulnerable groups are represented at all levels, including in positions of authority. Support for the development of a diverse criminal justice workforce is particularly important to achieving sustainable results and inbuilt capacity within criminal justice systems to ensure that the present and future development of law, policy and practice is underpinned by a commitment to non-discrimination and equal human dignity, and to ensure that criminal justice actors, the gatekeepers to justice, share a commitment to equal access to justice for all. I will leave my remarks there. Thank you very much.
Thank you so much, Wendy. It was a great wrap up of our session. What you shared with us. We don't have questions, but there have been a number of comments in the chat function, and I'm happy that colleagues have also responded to some of those. There was a request for the materials of presentations, and our hosts have indicated that they can be found on the Congress platform under the section of this event. And the recording will also be provided, I believe, at a later date. We have gone over the time almost by 10 minutes, so I will wrap up at this point. I would like to thank all our panelists for their presentations, sharing their observations and thoughts concerning the challenges in the field and the ways in which they can be improved in their own countries and beyond. My own reflection, as I was listening to all of you, are that 10, 15 years ago, only a handful of countries in the world provided effective access to legal assistance during police custody. Really, very few. I could count them on the fingers of my one hand. There was no particular standard or guideline concerning legal aid systems dedicated as such. And after 10, 15 years, now there's the UN Principles and Guidelines on legal aid. There are many jurisdictions which are working to improve delivery of legal aid rights. That instrument really catalyzed a lot of changes, movements for improvement of delivery of legal aid to suspects and defendants. And as we have heard now, there are also emerging good models and practices. Of course, they may never reach the perfection, but the idea that that there are dedicated institutions and processes and mechanisms that are being installed to realize those rights through standard operational procedures, through dedicated legal aid institutions, through training programs and capacity building programs. When they just described that investigative interview, which is the new really development globally that that hopefully will shortly soon will result in a UN document that provides guidance how investigative interview can be done in an effective manner in a way that creates, facilitates the better ways and more effective ways and more human rights based ways of investigations and realization of criminal justice objectives. So with this hopeful note as well, also noting that it was only first time during the last Congress that legal aid was recognized and given a dedicated article as a priority. And that has expanded further. The Kyoto Declaration goes into further details to underscore importance of timely and effective realization of legal aid principles, that it needs to be adequately resourced and be affordable, and then ways in which, and then importance of collection of data and data sharing that can facilitate the better understanding and deeper understanding of the systems and learning from each other. With those notes, I would like to wrap up now and thank again everyone, our speakers, and those who joined us as participants to this session. And I hope that our efforts, as they continue to generate concrete results, will inform future designs of the reforms in many other parts of the world as well. Thank you very much. And thanks to our hosts for really providing excellent support to facilitate our exchange today. Thank you.
Thank you. Bye.
Thank you.
Take care.
Thank you, Zaza. Bye.
Thank you. Bye-bye.
Bye.
Thank you. Bye.
Thank you. Bye-bye.